There are moments in law that don't make noise when they happen, but they change everything that comes after them. A single Supreme Court decision can quietly reshape how millions of people understand their rights, how states enforce rules, and how everyday situations are handled in real life. And when it comes to gun permits, concealed carry, and constitutional rights, even small legal shifts can create nationwide ripple effects that most people don't notice until they directly feel them. So here's the question. If the Supreme Court were to significantly limit or remove gun permit requirements, do you think that would make the system clearer and fairer, or more confusing and inconsistent across states? Share your opinion in the comments. Now, let's slow this down and understand what is actually being discussed when people say the Supreme Court ends gun permit rules. Because in my legal analysis, that kind of statement is often a simplified version of a much more complex constitutional process. The United States Supreme Court does not typically erase entire legal systems in a single sweeping move. Instead, it reviews specific laws and determines whether those laws are consistent with the Constitution. If a law is found unconstitutional, it is struck down, but only within the limits of the case being decided. To understand this properly, we need to go back to the foundation, the Second Amendment. The Second Amendment protects the right to keep and bear arms. But over time, the Supreme Court has clarified that this right, like all constitutional rights, is not unlimited. In District of Columbia v. Heller, the court confirmed that individuals have a right to possess firearms for lawful purposes such as self-defense, especially within the home. Later, in McDonald v. City of Chicago, that protection was extended to apply against state and local governments. This was a major constitutional moment because it ensured that states could not ignore the Second Amendment when creating firearm regulations. But the most important modern shift came with New York State Rifle and Pistol Association v. Bruin. In that case, the Supreme Court changed the legal test for evaluating gun laws. Instead of balancing public safety against individual rights, the court required that gun regulations must be consistent with the historical tradition of firearm regulation in the United States. In my legal analysis, this change is extremely significant because it removed a flexible balancing approach and replaced it with a history-based constitutional standard. Now, when people talk about ending gun permit rules, what they are often referring to is the idea that certain discretionary licensing systems may not align with this historical standard. Courts would likely examine whether permit requirements that give officials broad discretion to approve or deny concealed carry applications are consistent with historical firearm regulation at the time of the founding. There is a strong constitutional argument that discretionary permit systems may face increased scrutiny under this framework. At the same time, another perspective raised in court is that structured licensing systems can still exist if they are based on objective criteria rather than subjective approval. And this is where the legal complexity begins, because the Supreme Court does not simply say permits are gone or permits remain. Instead, it sets constitutional boundaries, and then lower courts interpret how those boundaries apply to real laws across different states. Federal versus state authority is also central to this issue. Even if the Supreme Court limits certain types of permit requirements, states may still regulate how firearms are carried, stored, or accessed, as long as those regulations do not violate constitutional protections. This means the result is not uniform elimination, it is legal restructuring. Different states may respond differently. Some may adjust their systems quickly to align with new interpretations. Others may revise their laws gradually, and some regulations may remain in place until they are directly challenged in court. From a real-world perspective, this creates a transitional legal environment. For lawful gun owners, this means the rules they rely on today may evolve over time. Not necessarily in dramatic ways, but in detailed ways. How permits are issued, what training is required, where carry is allowed, and how enforcement is applied. In my legal analysis, this is where legal awareness becomes critical, because most legal issues do not arise from dramatic violations. They arise from misunderstanding evolving rules. Now let's bring in the constitutional framework beyond the Second Amendment. The Fourth Amendment protects against unreasonable searches and seizures. In cases involving firearms, courts would likely examine whether law enforcement actions are justified based on specific, articulable facts rather than assumptions. The Fifth Amendment also plays a role in ensuring due process, particularly when individuals are subject to legal penalties or restrictions that must be clearly defined and consistently applied. Courts would likely examine whether firearm regulations provide sufficient clarity so that individuals understand what is required of them under the law. Now, looking at political and legal reality, even if the Supreme Court issues a significant ruling affecting permit systems, implementation does not happen overnight across all states. There is a legal process that follows: interpretation by lower courts, possible new lawsuits, state-level legislative adjustments, and administrative updates. This means the impact unfolds over time, not instantly. Supporters of reducing or eliminating strict permit systems argue that constitutional rights should not depend heavily on administrative approval processes. They emphasize the importance of clarity, consistency, and limiting subjective discretion in licensing decisions. On the other hand, those who support structured permit systems argue that regulation is necessary to ensure public safety, training standards, and accountability in how firearms are carried in public spaces. Both perspectives are part of ongoing constitutional debate, and both influence how courts evaluate these laws. In my legal analysis, the long-term direction of this issue is not a sudden nationwide uniform rule, but continued judicial refinement. Courts will continue to define where constitutional protection ends and regulatory authority begins, and that process takes time. Because constitutional law is not just about what changes, it's about how those changes are interpreted, applied, and tested in real life. So as we move forward in this discussion, it's important to think beyond headlines and focus on legal structure. Because what looks like a simple statement, "gun permit rules are ending," is actually a complex constitutional question involving federal authority, state discretion, and evolving Supreme Court interpretation. And now, I want to pause here and ask you something important. Do you think the Supreme Court should aim to create one clear national standard for gun permits? Or should states continue to have flexibility in how they regulate concealed carry within constitutional limits? Share your thoughts in the comments, because this debate is far from settled. In the next part, we'll go deeper into how such a ruling would actually be implemented, what challenges states would face, and what it could realistically mean for everyday gun owners in the years ahead. Stay with me, because this is where the legal theory starts turning into real-world consequences that affect millions of people directly. When we look at how Supreme Court decisions actually change everyday law, one of the biggest misunderstandings is the speed of impact. A ruling does not instantly rewrite every state system overnight. Instead, it sets a constitutional direction, and then that direction gets interpreted step by step through lower courts, state agencies, and legislative adjustments. In my legal analysis, this gradual process is not a weakness of the system. It is how constitutional law maintains stability while still evolving. Courts would likely examine not only the exact wording of a ruling, but also its reasoning, because that reasoning becomes the foundation for future cases that test similar issues in different states. So if a major decision truly limits or reshapes gun permit frameworks, the real-world effect would likely unfold in phases. First, immediate legal challenges in lower courts. Then, temporary differences in enforcement between states. And eventually, a more defined national standard once multiple cases align under consistent interpretation. This is where federal and state authority becomes extremely important again. Even under a strong Supreme Court ruling, states are not erased from the legal equation. They still retain the authority to regulate firearms within constitutional limits. That means states may adjust permit systems rather than eliminate them entirely, focusing on objective requirements instead of discretionary approval processes. There is a strong constitutional argument that any system involving the right to carry must avoid arbitrary restrictions and must be grounded in clear, objective legal standards. At the same time, another perspective raised in court is that states must retain enough regulatory flexibility to address public safety concerns in their own jurisdictions. Both arguments will continue shaping how future courts interpret these cases. Now, from a practical standpoint, this is where everyday impact becomes real. For lawful gun owners, the most important issue is not just whether permits exist, but how rules are defined, how they are enforced, and how consistent they are across state lines. A system that looks simple on paper can still create confusion in practice if different states apply different interpretations during a transition period. Courts would likely consider whether individuals had fair notice of legal requirements and whether enforcement practices were consistent enough to avoid confusion. That is where due process under the Fifth Amendment becomes relevant, ensuring that laws are not only constitutional, but also clearly understandable in real-world application. In my legal analysis, one of the most overlooked risks during legal transitions is assumption. People often rely on outdated rules or generalized information without realizing that a recent court decision may have changed how those rules are applied. That does not mean rights disappear. It means responsibility increases. Now, stepping back, the political reality of gun regulation in the United States is that it rarely moves in one direction permanently. Instead, it shifts over time through court decisions, legislative responses, and public debate. Supporters of more uniform national standards argue that constitutional rights should not vary significantly from state to state, especially when it comes to something as fundamental as self-defense. They believe clearer national rules would reduce confusion and improve consistency. On the other hand, supporters of state-level flexibility argue that local governments are better positioned to design systems that reflect their specific conditions, population needs, and public safety concerns. Neither perspective is disappearing. Both continue to influence how laws are written and how courts interpret them. Looking forward, the most realistic outcome is not a complete removal of gun permits nationwide, but continued legal refinement. Some systems may become more standardized, others may become more flexible, and many will exist somewhere in between until further court clarification arrives. In my legal analysis, that gradual evolution is exactly how constitutional systems operate. They do not rely on sudden transformation. They rely on structured interpretation over time. And that brings us to the most important conclusion. Whether or not gun permit rules are expanded, limited, or restructured, the core issue remains the same: understanding the law as it currently exists, not as it is assumed to be. Because in real life, legal outcomes are not shaped by headlines. They are shaped by how well the law is understood at the moment it matters. So as we wrap up this discussion, I want to leave you with one final thought. Do you believe that changing concealed carry laws through Supreme Court decisions creates a more consistent and fair legal system, or does it make it harder for ordinary people to keep up with their responsibilities? Share your perspective in the comments below. Civil discussion is how these issues become clearer for everyone. And if you want more clear, fact-based breakdowns of major legal developments that actually affect real life, make sure to subscribe for future updates. Because at the end of the day, the law is not just something written in court opinions. It is something you live with every single day, whether you realize it or not.